Welcome to our first presentation, in which we'll be relating to Chapter 6, which is about race and color discrimination. Let's begin. We're going to talk a little bit about the history of racial discrimination in the United States, very briefly talk about that. Then talk about the concept of race. Next, talk about the protections that are afforded under Title VII and other statutes relating to racial discrimination. Then also talk, of course, it's mainly a disparate treatment category, but we'll also talk a little bit about disparate impact and associational discrimination. In another lecture, we'll talk about racial harassment. We'll do a deeper dive into sections 1981 and 1983, and we'll end with a discussion of color discrimination. So let's begin. Obviously, our country has a long and very unpleasant history of racial discrimination. Obviously, you can go back to pre-Civil War days when there was slavery, but even after that, we continue to be a country that engaged in very overt and brutal discrimination towards African Americans. Many of these laws are grouped together under the name Jim Crow laws. These are laws that legalized racial discrimination, and they occurred in many parts of the country. Certainly they occurred in Texas and many other states in our part of the country. Things began to change to some extent in the 1950s. Certainly the Brown v. Board of Education decision was very important. It desegregated the schools, the public schools, and made the standard from Plessy v. Ferguson, separate but equal, no longer constitutionally acknowledged. Even though Brown v. Board of Education was decided in 1954, it was not immediately put into effect. And in fact, some schools weren't integrated for over 10 years after that date. Eventually, all the schools were integrated, but it was a slow process. And there was a lot of violence and other issues that came up before that was accomplished. Now, there is no legal or de jure segregation, but it continues to be true that our public education system isn't truly equal. Many of our least well-performing schools have a higher percentage of minorities, including African Americans, who attend them. And many of our strongest academic schools are primarily have students who are Caucasian. So these issues continue to be a factor in the careers and the development of African Americans. There are several laws that were passed in the 1960s that were designed to address issues of racial discrimination. We've, of course, talked a lot about the Civil Rights Act of 1964. We focused on just one of the titles, Title VII, which has to do with employment discrimination. But there were lots of other titles to that, or lots of other sections, public accommodation and other ones. The Voting Rights Act, though, is also a very important statute. It was passed the following year. And both of these laws continue to be in effect and continue to work to reduce the levels of discrimination that African Americans experience. We like to think sometimes that racism has gone away, and certainly there have been strides in that area, but we continue to be a country where there truly isn't equal opportunity. One of the terms that one hears is the idea of new racism, and that is people who think, well, there isn't any racism anymore. After all, we've got an African American president. Surely we don't have racism after that. But the reality is that while we've made strides, we continue to be a country where people, some people are overtly racist, some people have implicit bias, and these continue to be realities. I have a couple of surveys from somewhat long ago, but still, I'm sure if we were to do these surveys today, we would see many of these same statistics are in effect. and they indicate that there is a significant amount of racism against African Americans even today. We have seen in the last few years movements like Black Lives Matter, and related to that are cases such as George Floyd and other Breonna Taylor and other individuals who, African Americans who were subject to interactions with the police that have been interpreted as police brutality by many people, and have caused there to be protests and other actions to address that particular concern. So we continue to see this being an important part of modern day United States. As I've said, race is the first of the prohibited categories in Title VII, and it was what was on the mind of the people passing the legislation. Yes, it's only one of several categories, but it certainly was the primary focus. When cases are tried under Title VII relating to race, the cases are almost always about African Americans or Caucasians. There are obviously other races, but usually those races are identified as national origin complaints. So you can have somebody file a race claim based upon, say, that person is Asian. But more likely they're going to, let's say that their ancestors are from Korea, they're more likely to file their charge based upon national origin discrimination based upon their ancestors being from the nation of Korea, for example. Either way, it would work, but probably the smartest approach, if you represent a potential plaintiff, is to encourage him or her to sue under both race and national origin. A charging party doesn't have to choose one theory or the other, but a charging party needs to file his or her charge under Title VII under the theories that he or she plans to advance in the ultimate lawsuit. The interesting history with the term race used to have a much broader meaning than it does today. It wasn't unusual in the 1800s to hear someone refer to the Irish race, or the Jewish race, or the French race. And so the concept of nationality and race became or were seen as synonyms. Nowadays, most of us wouldn't use those terminology. We think of race as being distinct from national origin. But the idea of race is not an idea that scientists recognize. There is no DNA that we can look at that would tell someone, that person is, European or Caucasian. That person is Korean. That person is Hispanic. That person is African. There is no gene. In fact, studies have indicated that it's not unusual for somebody from one part of the world that might be very far from another part of the world. Those two individuals could have a great number of similarities in terms of their genetic legacy. So there is no DNA that tells us a person's race. There are no characteristics that definitively say a person's race. We may think that skin color is an important factor, and in our experience of race it is, but there are people in the world who are not from Africa who have as dark or darker skins than Africans. There are people who have lighter skin than people who live in Europe today. So skin color is not the only determinant either. When one thinks about it in these terms, one realizes that race is a social and a cultural construct, but it's not so much of a biological or genetic construct. It doesn't mean that it's not an important part of people's identity, that it isn't something they can get a lot of satisfaction and pride because of their connection to that community, but it's not a medical fact. The way that race is expressed in the United States can be multidimensional. We see nowadays that there's a higher percentage of Americans who identify as biracial or multiracial. And so that can raise additional issues. Somebody, for example, who has ancestors who are from Europe and ancestors who are from Africa might not identify as African American or Caucasian American. Might not identify as either, or might identify as both. And that person might have a different experience in terms of how he or she interacts in the workplace. Sometimes it can, can turn on how that person's appearance is interpreted. And so someone who has more features that are perceived as being consistent with an African ancestry might be subject to more discrimination than somebody who is biracial, whose physical appearance is perceived as being more similar to Caucasians. Again, we'll talk about color discrimination later on in this presentation. Sometimes race discrimination can be connected to other types of discrimination. For example, it might be that an African American man might be perceived incorrectly as being more likely to be violent than a Caucasian man or a Caucasian woman or an African American woman. African American who is Muslim might be viewed as someone who is more likely to be an anti-Semite than somebody who is from Indonesia who might be Muslim. Again, unfair stereotyping. So you have to be aware that it's not just, oh well, this person could only be experiencing discrimination because of one of these characteristics. They can have a cumulative effect, and it might be that in a particular place of employment, that employer generally doesn't discriminate against African Americans and generally doesn't discriminate against men, but does tend to discriminate against African American men, or whatever the category might be. And so you need to be a little bit more sophisticated in how you look at the data and how you draw the comparisons. Glass ceiling is an issue with both women and minorities. The idea here is that companies can have, typically they are implicit, not expressed. Maybe the company may not even be aware of barriers to success, paths that seem to work really well for Caucasian men to advance with an organization, but seem to present unexpected hurdles for Caucasian women and minorities of both genders. Figuring out what those roadblocks are is something that clients need to do, and many times the law firms can assist them in reaching those types of insights. I've talked about this in previous lectures, so I'm not going to spend more time on this. The EEOC has had an E-Race program going on now for several years. This is designed to make it better at identifying and addressing racial discrimination in the workforce. I'm just going to go a second to the website that they have here. And this kind of goes through their goals with respect to E-Race. You aren't responsible for spending time here, but if you haven't already, spend a little bit of time. Again, it's not an assigned task, but I recommend you spend a little bit of time getting familiar with the EEOC.gov's website, including its E-Race initiative. Color discrimination claims are on the rise, and they can arise in lots of different contexts. We'll talk more about that in our next presentation. By far, the most frequent claim that is filed is going to be a race claim. That's much more common than gender claims or national origin claims. And again, that reflects our country's very difficult history of racial discrimination and the fact that those problems continue. When I say that, I'm not saying that every single race discrimination claim has merit. I'm just saying that kind of where there's smoke, there's fire. And the numbers end up being about 36% of all of the charges. It's a little bit dated statistic, but my guess is the numbers would be very similar today. So a very significant portion of the charges are based upon race discrimination. So let's talk a little bit more about how we use the term race in a statute. And of course, we have some related terms that we want to do a little bit of a dive on too. So let's first of all talk about national origin. And this is one of these terms you'll want to use Quizlet for. So national origin, you can see it starts with the word nation. So it's the country or place from which an individual has originated. And of course, the person could be a native-born American born within the 50 states, but maybe his or her ancestors are from the other country. It doesn't have to be 100% of ancestors. It could be some subset of those ancestors. That would be how the term national origin is understood when we're talking about national origin. Again, we'll have a whole module on that. Color discrimination is again based upon skin color, complexion, shade, tone. This is another term that you'll want to work on with Quizlet or some similar tool. Color discrimination can occur within a race, or it can occur between races. For example, you might think, say, an African American manager wouldn't be discriminating against another African American manager. And that seems unlikely. It could happen, but it seems unlikely. But it's more likely, perhaps, that there could be color discrimination. Perhaps the African American manager has a lighter skin tone and prefers African Americans who have lighter skin tones. And so if there was an employee who had a darker skin tone, and that supervisor might discriminate against him or her. Or it could be the other way. Maybe the supervisor has a darker skin tone. There certainly does tend to be in our culture greater discrimination against African Americans with darker skin tones in some cases than those who have lighter skin tones or who have physical characteristics that suggest more of a European family tree than a purely African family tree. As we said before, race is not defined in the statute, and as we said, it isn't a ancestry. I mean, it isn't a blood test that you can take. It has to do with the family tree. It has to do with culture. American isn't a race, but Asian is a race, white is a race, black or African. They are all races. There can be great diversity within a race, many different skin tones, many different particular characteristics in terms of, the shape of the face and the shape of the various components of the face. All of those things can be very different across a broad region. Sometimes it's not possible to tell differences. I don't think a person can tell a French person from a German person. But I think sometimes you can tell a French person, say, from a Russian person. Not infallibly, but there are some characteristics. And in most cases, it's probably possible to tell a Spaniard from a Scandinavian person, for example. So there are some tendencies, but there is no bright line that distinguishes it. Similarly, there are differences in appearance across Asia and across Africa that parallel those same differences that we might see in Europe as well. Let's talk about Section 1981 because it also discusses the topic of racial discrimination. As you probably recall, it is one of those Reconstruction era statutes that was designed to eliminate the black codes that existed in many southern states that were very onerous to African Americans. Now, the Section 1981 does not define race. It simply uses the term racial discrimination. And so some courts have said, well, race has to do just with Black, white, Asian. It doesn't have to do with national origin type issues. That's what some courts have said. Other courts have taken the opposite view. They've acknowledged that back in 1866, when Section 1981 was passed, that the term race was a broader term, including concepts like national origin. Again, there's differences. Courts have come down on both sides. By the way, I somewhat tweaked this language, so if you have an earlier edition of this slide, you may see that I've added a little bit more to explain that this is somewhat of an influx issue. So certainly if your client is advancing a national origin claim, you ought to go ahead and advance a Section 1981 claim. Obviously, if your client is advancing a race claim, it's a no-brainer to also include a Section 1981 claim. So let's move. We've talked about the history. We've talked about how the term race, what it means to scientists, what it means to the everyday person, and also what the statutes have said that it means. Now let's talk about racial discrimination. So as I said, Title VII was written, I don't say exclusively, but to a large measure to address racial discrimination. And most of those cases that have arisen, the vast, vast majority have been disparate treatment claims. As you recall, there are the two categories, disparate treatment and disparate impact. Disparate treatment is when somebody discriminates because of a person's race. That's what we think of when we think about racial discrimination. Disparate impact happens when there's a facially neutral policy that is applied consistently but happens to have an adverse impact upon a certain group, which certainly can include African Americans and or could include Caucasian Americans. So it is possible to have a disparate impact claim relating to race, but certainly disparate treatment is the most important of the categories. Oppositional activity is also covered. That's typically retaliation type claims, and we'll talk about that in more detail as we go forward in this module. You can also have racial harassment. Racial harassment in many senses parallels the law for sexual harassment, but there are some important differences, and we'll talk about those. You can even have discrimination situations arising where somebody is misidentified as an African American. The person actually is from a different part of the world. That person might be discriminated against because of the mistaken view that he or she is African American. That would still be a violation of Title VII because the person has still been discriminated against based upon the race that he or she is perceived to have. Let's consider a couple of scenarios. So Bob has a large number of Hispanic employees. There's no evidence Bob discriminates against any of those individuals. Bob denies Susan a job because he thinks incorrectly that she's a light-skinned African American. In reality, Susan is not African American, she's Hispanic. Even though Bob does not tend to discriminate against Hispanics, and if he had understood that Susan was in fact Hispanic, he probably wouldn't have discriminated against her. Bob has still violated Title VII with respect to Susan, specifically the race discrimination parts of that law. Let's consider another scenario. This is a different Bob here. Bob is Caucasian. He would like to promote Mary, an African American waitress, to become an assistant manager. The owner of the restaurant is racially biased, and he tells Bob, no, you can't do that. Bob is, I guess I need to change this. This should be Mary. Apologize, that's a typo there. Bob's extremely frustrated by this instruction because he thinks Mary is the most qualified person for the position. So he disregards the owner's instructions and goes ahead and promotes Mary to the position because he thinks she's qualified. The owner fires Bob. In this case, Bob can, obviously it's not a racial discrimination claim because we'll assume that the owner is Caucasian. The owner isn't firing Bob because Bob is white, but he's firing Bob because Bob refused to discriminate. And so Bob engaged in oppositional conduct. So Bob's cause of action would be for retaliation, not for racial discrimination. But retaliation is, of course, a protected category under Title VII. So let's consider some of the special issues that arise in race and color claims. One can be offensive terminology or symbols. Obviously, we know many of the offensive terms that exist. Offensive symbols can be KKK or a noose or a white hood. Those types of things can be used to intimidate individuals and create a very hostile work environment. We also have inaccurate cultural assumptions about individuals that might fit into a particular racial group. The whole idea of stereotypes are that we're using a generalized concept which may or may not be true for the general group. But even if it is true for the general group, it's not going to be true for every person who's a member of that group. And that's the problem, that we ought not be saying, oh, I've identified that person's race, so I know something about that person's lifestyle, that person's work ethic, that person's education, that person's accent, that person's political views, or whatever the particular issue might be. So what does a race discrimination plaintiff need to do to be successful? Well, it's the same thing that we were talking about in earlier presentations. Remember, we had the bouncing ball. The first thing the plaintiff has to do is make that prima facie case. He or she has to prove he's a member. We'll say he, to put the pronoun straightforward. He is a member of the racial group that he claims to be a member of. We'll say he's African American. That he applied for or had a particular job, that he was qualified for the job, and that he either didn't get the job or he was taken out of the job. Those four things. And usually there isn't any problem proving any one of those four things. The fifth thing is kind of one other piece of evidence. It's a little bit vague, but the most common piece of evidence is that somebody of a different race was hired instead of the client, or when the client was dismissed from the position. But there can be some other things that also have that wrong. So once the plaintiff has made that prima facie case, which is usually not hard, then it goes back to the defendant to provide an explanation for the actions that are not racist. For example, I didn't fire Bob because he's African American. I fired him because he was the last person hired, and we needed to lay off people because our business was not thriving. And so once the defendant has presented a response, then the ball goes back to the plaintiff's court to present a rebuttal to show maybe that wasn't true. Maybe yes, maybe Bob wasn't number one. Maybe Bob wasn't the last hired. And even if he was, maybe the company would not have had the layoff if the most recent hire had been an Asian person or a Caucasian person. And so those would be some responses that the plaintiff could advance. So the plaintiff can use the prima facie case network, which of course is based upon circumstantial evidence, or direct evidence. Bob is fired. The supervisor has been calling Bob offensive names throughout his employment, or says to Bob, we don't want your kind around here, or something along those lines. It certainly implies that Bob's race was a factor in the decision. In Module 5, we talked about affirmative action programs. It's a extra credit unit, so you don't have to complete it. But if you have, you're familiar with the fact that companies that have affirmative action plans can take more aggressive actions at balancing their workforce to reflect the diversity of their community. Employers that don't have affirmative action plans can't engage in anything along the lines of reverse discrimination. Now, just having an affirmative action plan doesn't mean you get to engage in reverse discrimination. And by that I mean, when I say reverse discrimination, I mean preferring African American candidates over Caucasian candidates. It's a complicated issue. We have relatively few employers in our part of the country that have affirmative action programs. Most of the ones that do have them because they're federal government contractors. And so, of course, if you are facing a client who has who's a federal contractor, or if it's in a similar situation and therefore has an affirmative action program, you have to be really careful about threading the reverse discrimination needle. If your client doesn't have that, then there is no leg you have to stand on to consider any kind of informal affirmative action. Other than, well, let me put it this way. There are things you can do that don't, there are affirmative action steps you can take that don't involve preferring African American candidates. And those affirmative action steps, such as casting a wide net, advertising in lots of diverse locations, you can and should do that whether or not you have an affirmative action program. But preferring people of a particular race over Caucasians, that's something that can only be contemplated when there is an affirmative action program. And even then, it has to be done very, very carefully. Okay, so Mary is a Black woman. She works for Llama Magazine for 5 years. She applies for a promotion, but Deborah, a white woman, actually gets the job. Deborah has better qualifications than Mary. Maybe she has a longer period of time with the employer. Maybe she has more academic experience. Maybe she has better job appraisals. Mary feels, though, that despite Deborah's better qualifications, this was an example of race discrimination, so she files a claim. Under these facts, assuming that it's true that Deborah does in fact have better job qualifications, Mary's claim won't prevail because she wasn't denied the promotion for racial bias, but because Deborah was the better candidate. Recognizing race discrimination can be a tricky thing because, once upon a time, if we were 50 years ago or 60 years ago, racists might be very public about their their racism. It was much more socially acceptable to talk in those terms. Nowadays, people who have racist views are more likely to be careful and to not share those views. And in some cases, they themselves are not aware that they have those views. And so racism can be very subtle. When I say it's subtle, it doesn't mean that it doesn't have a very significant impact upon people. What I mean is it's difficult to identify a single action that is indisputably racial discrimination. One of the things that employers can do to help in this area is to listen to their workforce, to see what's happening and what the concerns are, so that they can address those concerns and respond to those concerns when they arise. Now, none of this should be interpreted to mean that somehow or another anyone can get away with poor job performance. Obviously, somebody who's performing poorly in his or her job, no matter what his race or religion or age or gender is, that would be a legitimate non-discriminatory reason to engage in disciplinary action, including dismissal. Let's consider this scenario. So Juan is a chemical engineer. He is from the Dominican Republic, so he's culturally Hispanic, racially African. His employer dismissed him after 10 years on the job. They alleged it was due to poor performance. According to Juan's supervisor, Juan continued to be the least productive person in the department in spite of frequent feedback and training that he received. Here's the clincher. Objective evidence supports what the supervisor is saying. There's statistics that show this isn't just the supervisor being a bigot, but is actually what was happening in the workplace. Juan thinks he's got a good claim of discrimination because he's the only Hispanic and African in the department, I'll say. Juan, however, actually doesn't have a good claim because his poor performance has been documented, and that is a legitimate non-discriminatory reason. So now we're going to look at some documents that are relevant to race discrimination. We've talked about Title VII in the past and Section 1981. You may recall Section 1983 is the statute that has to do with government action. It's not going to be a major focus of our course because we focus on private employers. Okay, so again, the smart plaintiff who is filing based upon race discrimination is going to assert claims under Title VII and Section 1981. Again, as I said before, Title VII protects every person. Every person has at least one race. Many people have more than one race. And so everyone is protected by the racial protection under Title VII. Let's consider this scenario. So Mary is white, Bob is black. They both work at Eager Beaver Market as cashiers. And they together decide that they're going to steal some beer from Eager Beaver. Mary's watching the front of the store, kind of being a lookout. Bob loads the beer in his truck. Neither of them know that there are security cameras. The owner sees the security cameras and he terminates Mary, but gives Bob a final warning. Now, but they were both in cahoots in this scenario, and Bob is the one who actually carried the beer out. So if you were going to say one was more guilty, you'd probably say Bob was the one who was more guilty. And yet Mary is dismissed and Bob isn't. That sounds like it's an example of race discrimination. Mary is treated less advantageously than the African American co-worker. Now, there could be other reasons. For example, maybe this is Mary's second time to be involved in theft. Or maybe Mary was in her probationary period, whereas Bob was a long-term employee. Or maybe Bob is a special needs person, and Mary was able to coax him into doing something that he never would have done on his own. So it could be that there are facts that would cause us to look at this case differently. But given the facts as we see them, as they're presented to us, it seems that Mary and Bob should have received the same consequence, which honestly should have been termination, but the employer is entitled not to terminate if it doesn't want to. Let's consider the McCullough case. Was McCullough subject to racial discrimination? So Ms. McCullough was a college-educated African-American woman who worked at a deli counter, and she worked there for many, many years. The grocery store was sold to another individual named Ron Meredith. Ron also hired another worker, Kathy Craven, who is Caucasian, to work on the deli counter. Kathy did not have any deli experience, and she had significantly less education than Ms. McCullough. 3 months after Craven's arrival, the owner, Ron Meredith, decided to appoint one of the deli employees to be deli manager. There's only two of them, so it's either going to be Cynthia or Kathy. You can probably see where this is going, right? He it promotes the new hire Caucasian with no deli experience. McCullough thinks that Craven was promoted over her because Craven's white and McCullough's black. And again, she points to her work experience and her education. The case eventually got to the Court of Appeals. I think it's the 11th Court of Appeals. Let me make sure. No, it's the 8th Court of Appeals. Sorry. Of course, we're in the 5th Court of Appeals. The Court of Appeals said, yeah, this does seem kind of fishy. You know, it's not that the employer can't maybe prove. I mean, just because someone has more years of experience, maybe she's just really bad at it, even though she has lots of years of experience. And, you know, I'm not sure that the college is really that relevant to deli work. Maybe it is. But it could be that there are reasons that justify Craven's promotion over McCullough. One of the things to keep in mind, and the procedural history shows us, is that the trial court granted summary judgment. So the trial court did not allow the jury to hear all of the evidence and reach its own decision. What the trial court said was that Ms. McCullough wasn't able to present even enough evidence to get the opportunity to present to the jury. So the Court of Appeals, the 8th Court of Appeals, is not saying McCullough wins. They're simply saying McCullough ought to get her day in court. She ought to be given the opportunity to try to persuade the jury. Maybe she'll be successful and win. Maybe she won't. That'll be for the jury to decide, but it shouldn't be the judge who removes the case from the jury, because there is a triable fact under these circumstances. This particular case you do not, this particular case you do not need to know. It's just a good example of kind of how these cases develop. Okay, this is a U.S. Supreme Court case. You don't need to know this case either. In this particular situation, two African-American superintendents, I guess it's probably like a supervisor, apply for promotions. They aren't selected. Two Caucasians are selected instead. They file charges alleging race discrimination, and part of the evidence they present in support of their claims of racial discrimination is that the person who made the decision would refer to them, even though they are adult males, as boys. And that suggests, obviously this is a very fraught term with a lot of historical meaning, where African-American men have been infantilized by referring to them as if they were not adult individuals. And so this name calling the plaintiffs alleged was evidence of a racial bias. Well, the jury sided with the plaintiffs and said, yes, it does appear that these two plaintiffs were passed over for the job based upon their race. But the district court said, I don't think there's enough evidence to support that claim. Because keep in mind, the plaintiffs bear the ultimate burden of proof. It's only preponderance of the evidence, but they have to make it more likely than not that they, in fact, were the victims of racial discrimination. And the district court wasn't buying it. So it ultimately went up to the U.S. Supreme Court, and the U.S. Supreme Court's job was to say, well, is there enough? And the U.S. Supreme Court said, yep, racially offensive epithets like boy could be proof of discriminatory intent. And so the case went back down to the trial court. Let me pause and talk a little bit about some of this procedural stuff. You don't talk a lot about procedure in this class, but since I'm using some terms here that you may not be familiar with, first thing to note is that the decision was unanimous, which means assuming there were 9 judges on the court, 9 justices on the court, it was a 9-0 decision. All the justices were on one side. It was also per curiam, which means that no judge actually signed the decision. Per curiam decisions are almost always unanimous, and oftentimes the decisions are quite short. In this situation, the Supreme Court probably wasn't trying to develop a lot more law in this area. They were probably trying to just address this particular very narrow issue, and that's why they issued a per curiam decision. Interestingly, despite the win that Mr. Ashe had in the U.S. Supreme Court, and despite the fact that he was able to persuade the jury, he was not ultimately successful, because when it went back down to the trial court still found for the defendant, finding that there was no racial animus or intent to discriminate. And so Ashe lost. Now you may be saying, well, that's appalling. They overturned the jury decision. These two adult men were treated to offensive terms. How could that have been permitted? Well, keep in mind, we don't know all of the facts. If we knew all of the facts, we'd probably be in a better position to understand why that judge ruled as he or she did. It could be that the two people who were promoted, the Caucasians, had more service, had better performance records. There may have been significant evidence showing that those two individuals were better qualified. Maybe not. I haven't looked at the cases myself. But just keep in mind that we've been looking at just a handful of facts, and typically these cases have many, many more facts. So I make this point to show you that even winning in the U.S. Supreme Court doesn't necessarily mean that you're going to win at the end of the day. The U.S. Supreme Court is not a trial court. All it can do is just send that case back down to the trial court for resolution. Obviously, the case could then go up again on appeal, but as far as I know, it did not. So this is a hairstyle that is called a finger wave hairstyle. It has at times been very popular with African American men and women, but it is also popular with Caucasian women. I don't know necessarily of Caucasian men having this style. But you can see it's a very attractive hairstyle, and so it's been worn again by both ethnicities. So the question is, can a disparate treatment case of racial discrimination arise from an employer's grooming standards? And the answer, you probably know before we even go here, is yes, of course it can. You can pretty much discriminate against anything, and it's unlawful when you do. So in this case, our plaintiff is Eunice Hollings, who is an African American. She worked in an industrial setting, and her employer's grooming policy stated this: women should have a neat and well-groomed hairstyle. Rollers and other hair setting aids are not permitted. For safety, women may be required to have their hair tied back. So that's the policy that Atlantic is about to enforce with respect to Ms. Hollins. So Ms. Hollins started wearing her hair in the finger wave style. So she was doing something like this with her hair. She's African American, so I'll use Holly, I guess is that Lisa Bonet? Holly wearing Lisa Bonet's hairstyle. The foreman informed Hollins that her style was unacceptable to the company because it was too different and did not meet the company's policy. Now, there doesn't seem to be anything in here about it needing to be not different. It needs to be neat and it needs to be well groomed. I don't have a picture of Ms. Hollins' hair, but I would describe all of these hairstyles that I'm seeing as neat and well groomed. And there's certainly no rollers present in those examples, nor other hairstyling aids. And some of the women's hair is long, like Marilyn Monroe's, but most of this may be a little depending on how we define long. I guess the concerns can be about safety if you're operating machinery. But it looks like that there wasn't an issue about the length of hair. So the next day, Hollins came to work with the same hairstyle. And again, she was told, don't do it. And if she was told if she didn't like the policy, she wouldn't be able to work here. The plant manager thought that the hairstyle was eye-catching and therefore inappropriate. I guess his point is that it was possibly going to distract workers. Again, there's nothing in the policy that says anything about it needing to be not eye-catching. Hollins, I guess, wanted to keep her job, so she decided to change her hair to a more plain style, less quote-unquote eye-catching, even though she preferred her finger wave style. But this is the most important part of the story. Hollins maintained that the grooming policy was not applied to Caucasian women. So that's her allegation. We don't have specifics in the case. And so ultimately, Hollins felt that the company was antagonistic toward her, so she ultimately filed a charge of discrimination. And initially, the district court, the trial court, granted summary judgment, probably on the basis of, why are we worrying about hairstyles? That seems like a trivial thing. Wear your hair the way your boss wants you to wear your hair, and let's move on. And that is oftentimes the result of the decision of courts in this area. They are not likely to find sexism or racism or national origin discrimination with respect to dress codes and hairstyle requirements. But in this case, the court said that the disparate treatment aspect is what makes this case different than your typical dress code case. If the employer had consistently applied this eye-catching hairstyle to African Americans and Caucasians, then Hollins would not have had a leg to stand on. But since it appears that Caucasian women were allowed to wear quote-unquote eye-catching hairstyles and African Americans were not, that's an example of disparate treatment, and therefore, again, that doesn't mean that Hollins is going to win. It just means that the case is going to be sent back down to the district court for a jury trial to happen. So Hollins may win on appeal. Let's consider the situation of Rashid. So Rashid's an African-American man with a bachelor's degree in physical education. He has a white friend who also has his credentials. They both apply for a job working for a gym. The white friend gets an interview, but Rashid does not. Rashid's thinking, maybe it's my name. There's nothing else on my resume that suggests my race, but Rashid is perhaps a name that the gym may have associated with African Americans and or Muslims. So Rashid takes his resume, keeps it identical, except he removes his name and puts the name Bob. So he's now Bob Olson when he submits his resume. Well, Bob is invited to an interview. Under these facts, it's pretty clear that Rashid was the victim of race discrimination based upon the perception of his race in his job application. This is very common. There's lots of studies that have been done that show this is absolutely a real thing. Some approaches that African Americans and other minorities do is using initials or using a nickname that may have a more neutral meaning to it. On the other hand, not surprisingly, many people are very proud of their names and their history and wouldn't want to hide it for the world. And perhaps they want to know if their potential employer is bigoted because they don't want to work for a bigot. So it's a good source of information that the applicant is getting at the same time that the employer is getting. Let's consider some defenses that may be available to an employer in a racial discrimination case. First of all, one defense that we've talked about with respect to sex and religion is the bona fide occupational qualification, the BFOQ defense. That is not available for race. There is no particular thing that only Caucasians can do or only African Americans can do. keep in mind that no matter how strong the customer or coworker preferences, that cannot be a factor in making the employment decision. If the claim is for state discrimination under Section 1981, keep in mind that the statute of limitations for those claims is quite short. So it may be that that state employer is going to be able to assert a statutory bar because the statutory period has expired. Let's discuss the relatively common requirement that certain workers live within the geographic bounds of a government unit. So for example, if you want to be a firefighter for X town, that firefighter has to live within the geographic borders of that town. You want to be a police officer, or school teacher, or whatever the particular position is. Well, some communities have relatively low minority populations, and sometimes they have low populations because they don't have affordable housing. That seems like quite a coincidence, doesn't it? And sometimes it is just a coincidence, but sometimes it is on some level an intentional decision by the locality to keep the community largely Caucasian by not allowing more affordable housing in. As a result, it may be hard for African American candidates or Hispanic candidates to secure housing in that particular community. And of course, if they already have to live there before they can apply for the job, most of us don't move for the mere fact that you can apply for a job that you might not get anyway. So sometimes these residential requirements do cause a disparate impact and can create such a claim. Now, if the community is balanced, let's say, there's a 60% white, 20% Hispanic, 20% African American population, or something like that. I'm making up numbers here. Even though a particular African American might not live in a city, and so he or she is ineligible to apply to become a police officer, for example. The population of the city itself is balanced, and so therefore there probably isn't a disparate impact in that circumstance. So you'd be looking at the statistics overall, not how this policy affects an individual candidate. So let's consider the things that racial discrimination encompasses. One, it encompasses just the biological reality of who one's ancestors are, the ancestry. It also relates to physical characteristics. This could be skin tone, this could be other characteristics that are oftentimes identified with a particular racial group. It can also relate to race-linked diseases such as sickle cell anemia, which disproportionately impacts individuals who have ancestors from Africa. If the sickle cell mutation is one of the body's responses to as a way to protect the person from malaria. And so typically places that you see sickle cell anemia are places that have a relatively high incidence of malaria, and some of those places are in Africa. So that although there are other particular situations where other groups around the world can also have sickle cell anemia. And you can have that race plus situation. We talked about sex plus when we talked about situations where an employer doesn't generally discriminate against women and doesn't generally discriminate against parents of young children, but may tend to discriminate against women who have young children. And that is unlawful as a sex plus situation. And you can have race plus when you, for example, you don't discriminate against African American women, and you don't discriminate against African American men and women who are, say, over 40, but you do discriminate against young African American men. That would be a race plus category. There's also protection against associational, and obviously this is a Quizlet term, I didn't provide a definition, but hopefully you've gotten the gist of the meaning. Association discrimination is another category. This doesn't just apply in a race situation. You can have association discrimination under lots of circumstances, but one way it arises is when you treat someone less favorably at work because of marriage to somebody of a particular race or other association. Maybe it's a roommate situation, or maybe the person has adopted a child of a different race. And so while the person who you are discriminating against may be of your same race, you are discriminating because of that relationship that person has with the person of another race. So let's consider a scenario. Mary's a white woman. She's married to an African-American man. Perhaps no one in the office knew that Mary's husband was African-American. Mary's husband drops into work one day. People observe that he's African-American. A few days later, Mary is dismissed for no reason. Mary would have a claim of discrimination by association. This association discrimination could apply in other circumstances. Maybe Mary was married to an Hispanic person or a Muslim person, or maybe Mary is 25 and she's married to a 65-year-old, so it could be age discrimination. So there's lots of different ways that these associational claims can arise, but certainly they can occur in the racial area. Race discrimination can be about, so we're still continuing our list of the categories we've talked about. I guess so. I apologize, went too far. I hear that. Okay, here it starts. Okay, so we talked about ancestry, their physical characteristics, race-linked diseases, race plus association discrimination, and on the next slide we have culture and perception. So there's something so-called the black accent. It's a speech pattern that obviously is not genetic, but it may reflect a cultural value, a way of communication that is special within a particular community. And so discriminating on that basis would violate Title VII, even though a person could be of a different race and have a black, quote-unquote, black accent. And you cannot, as a general rule, discriminate based upon an accent unless the accent makes it difficult for that person to do a job. And obviously a black accent is understandable to people who don't happen to have the black accent. So that would not be an example of something that could be the basis of lawful discrimination. Then Title VII prohibits discrimination based upon cultural dress, grooming practices, accent, or manner of speech. Now, an employer is still entitled to have a dress code, and so the employee can't wear his or her cultural dress if that violates the dress code. But let's say the dress code is, standard office apparel, and a woman comes to work wearing a hat that reflects her African ancestry. That would be completely appropriate unless, of course, the employer prohibits people from wearing hats. Under those circumstances, the employee is permitted to wear her cultural expression. Let's consider this scenario. Bob owns this company. He never has made an African-American employee a supervisor because Bob believes that his crew of workers, who are primarily Asian, will not follow the instructions from an African-American supervisor. So Bob is saying, I'm not a racist, I just employ racists. Or the other common way that we see this presented is, I'm not a racist, my customers are racist. And so I have to be a racist to meet my customers' needs or to ensure there's a pleasant work environment. That is never an acceptable excuse for discrimination. Bob is guilty of disparate treatment of all the African American candidates that he passed over for promotion. You can't make employment decisions based upon racial stereotypes. So in this situation, different Bob obviously, is an African American with a law degree. He's hired as the first Black attorney in a law firm. He handles routine assignments well, does a good job with them. But as time progresses, Bob sees that he's not receiving more complex assignments as other people at his level within the organization are receiving. And these other individuals are Caucasian. Obviously, this is going to limit Bob's progress within the firm because he's not able to show all of his skills and is not able to learn new things. So Bob goes to his boss and says, hey, I'd like to get some work like these other individuals are getting so I can develop. But Bob is told, nope, do what you're assigned, that's your work. Under these circumstances, Bob would have a claim of discrimination because it appears that this employer, even though it hired him, they were so proud of the fact that this is the first Black attorney, but the people who are giving him work assignments obviously have offensive assumptions about the skill set that an African American would have. Now, it's important to keep in mind in this story that Bob performs these routine assignments well. Obviously, if Bob had been doing poorly, or maybe just, okay, but nothing great, then the answer would be different. But in this situation, we see Bob is doing well, and so he ought to be getting the same assignments that the other attorneys who are doing well are receiving. Obviously, employer can't race segregate. So you can't have one locker room for African Americans, one restroom for African Americans, one recreational area for African Americans. Now, it's fine if employees during their off-the-clock time choose to self-segregate. Let's say there's a break room where everyone is entitled to be, but it just so happens that there ends up being a white employee table and a Black employee table. That's fine. There's not a requirement that the employer come in and say, okay, we're going to sit in alphabetical order or something along those lines. Now, when segregation happens when folks are on the clock, that does become more problematic. Sometimes workers will prefer to work with people of their own race. And if people are left to decide kind of what workstation they're going to be at, they may well choose to be grouped with people of their same religion or the same age or the same gender or whatever. That becomes more problematic. I would discourage an employer from permitting racially based grouping, even when it's completely at the employee's decision. Let's discuss the topic of strict scrutiny. Now, we've been talking about private employer action to this point, but of course, the government can also discriminate against people. And so the standard that applies when the government treats someone differently because of that person's race, we call that standard strict scrutiny. And that's the usual standard that we see in race issues. There has to be a very compelling government need before you can have classifications based upon race be upheld constitutionally. I would probably argue that it would never be able to be approved. I have heard of cases wherein charter schools have tried to establish schools, say, for just a particular ethnicity, usually African American, and the idea is that it may be a positive learning experience for African Americans to truly experience the complexity and beauty of their culture in a way that maybe the popular culture doesn't allow them to see. And having people of other races present might interfere with some of that transmission. But I think that those types of schools, if they exist, have probably run afoul of the strict scrutiny requirement. So I would say that it's unlikely that you would be able to see a government action that attempts to classify or segregate people based upon race. So at this point, we have completed our first section, our first half of our module about race and color discrimination. We talked very briefly about the history. We talked about what race means, both in terms of biology and in terms of how these terms are defined in the statute. And we've looked at racial discrimination both as a disparate treatment topic, a disparate impact topic, and a topic of association discrimination. In our next presentation, we'll talk about racial harassment. We'll do a little bit deeper dive into the sections 1981 and 1983, and we'll end with a discussion of color discrimination. As always, I thank you for your attention. I hope you've enjoyed this presentation, and I hope you have a wonderful day. Take care.